Now, the third speaker is Judge Ida Caracciolo from ICLS, whose subject is the role of scientific experts in international adjudication and how international courts and tribunals assess scientific evidence. These, I think, are they're recognized as increasingly important questions. The approach is something that is developing rapidly and, in my view, developing in the right direction, but I'll be interested to see if Judge Caracciolo agrees with that. Judge Caracciolo is a very distinguished international lawyer, Italian international lawyer with extensive practical experience in the law of the sea, and also as a generalist international lawyer. Very relevant to her subject today is that she has represented Italy before the International Court of Justice, before ICLS, and before other international courts and tribunals. Judge Caracciolo, you have the floor.
Thank you, Sir Michael. First of all, let me say that I'm really pleased to be here in Incheon to attend this international conference on the law of the sea, and I wish add my thanks, my sincere thanks to the organizers of the conference, the Korean Ministry of Foreign Affairs, the International Tribunal for the Law of the Sea, and the Korean Society of International Law. I will address a topic concerning the relationship between international law and science and technology on the other side of the barricade, I will say on the side of procedural law. In doing so, I will express my personal opinions. As Judge Pike has already highlighted, new technologies and scientific developments have posed and are still posing to the international adjudicator many challenges. One of the methods more utilized by the international adjudicator is the recourse to experts, to scientific experts during international proceedings. I won't analyze all the topic, which is really wide, but I will just focus on some aspects which seem to me instrumental to a better and description of the topic and can be a base for understanding better the possible evolution of these mechanisms. The first point will be the non-existence of a unique category of experts, but on the contrary, two well-differentiated categories, ex curia experts and ex parte experts. The second point will be the advantages for international tribunals and courts to having recourse to ex curia experts, but at the same time the heavy challenges that this choice poses to international adjudicator. And then I will analyze the limits to the recourse to ex parte experts, especially concerning the assessment of their independence and their impartiality. Of course, given the topic of this conference, which is focused on the law of the sea, I will analyze the relevant statutes or better, I will refer to the relevant statutes and rules of procedure of those judges which may have jurisdiction on the law on the sea, so namely ICLS and ICJ and Annex 7, UNCLOS Annex 7 tribunals. Even if very interesting experience have been carried on by WTO disputes chambers in this field. Well, we usually, concerning the first point, the categories of experts, we usually say scientific experts in general terms, but indeed there are two well-distinct categories, the ex curia experts and ex parte experts. Their roles are different, their function are different, and their advisability must be assessed differently. The limitations of one category cannot be replaced by having recourse to the other. I will say that the two methods are parallel but neither interchangeable between them. This situation stems from their origins. Ex curia experts were taken from civil tradition, where domestic judges look for the truth, and this research for truth is conducted by the judge alone. He can just ask the assistance of auxiliaries, among them, the most important among them, experts. On the contrary, ex parte experts come from the common law tradition, where it is for the parties to present and to propose to domestic judges their reconstruction of the facts and including technology and science. You can easily understand that these two completely different ways of thinking the role of experts cannot be overlapped. So the only solution is to take advantage of the existence of these two methodologies that international judges alone can utilize at the same time. And also we can think that in extremely difficult, complex cases involving technological and scientific aspects, all these methodologies can be utilized all together, ex curia experts and ex parte experts. Why not? Since they are carry on very different functions, and they can mutually useful for the best outcoming of the decision making by international judges. Judge Pike has already highlighted that there are two categories within the category of ex parte ex curia experts of experts. The so-called expert assessors, which are disciplined by Article 289 of UNCLOS, which is a quite innovative provision within in the Convention, which is a specific, special rule, so it prevails over different dispositions contained in relevant concerned statutes and rules of procedure. Expert assessors are really unique, since they participate very close to the decision making by international courts and judges without having, of course, the right to vote. On the other side, I will say, stricto sensu, ex curia experts are, they give the judge their knowledge, their skills, their expertise when the judge thinks not to have sufficient one, but they they play a minor role compared with the role of expert assessors. Well, the general idea is that both categories of ex curia experts can be very, let's say, dangerous for international tribunals and courts, and indeed they have never been utilized so far by both the Tribunal and the International Court of Justice, since they could deprive the judge of his uniqueness. They can be considered as external actors subtracting the decision-making power to the judge. But indeed, what this can be, these concerns can be, of course, shared, and they are largely discussed by scholars and judges themselves. But what they give, and this is an important aspect, in my opinion, to international courts and tribunals, is their independence and impartiality, in the sense that they are appointed directly by the judge from groups of people, or lists in the case of Article 289, which are maintained by international specialized agency to the UN, so with the highest level of knowledge, skills, impartiality, and independence. So in cases where the scientific opinions can be very clashing one to the other, the participation of expert assessor may offer the idea of impartiality and independence in a better way than ex parte experts. It is also true that obviously international judge is called to a very delicate reasoning when the adjudicator decides to utilize ex curia experts. He needs, first of all, to judge his scientific and technological knowledge and skill, which is not something simple to do. It is the judge of himself or herself vis-à-vis science and technology. And then once the adjudicator is arrived to that point, he must be able to control all the time the activities by ex curia expert. The international judge is always a court of law, not a court for science or technology. So the activities conducted by ex curia expert, but must always pass through the lens of legal reasoning, through the lens of international law. On the contrary, we will have a dispute on the facts and not anymore a dispute on international law. The practice of international tribunals and courts concerning stricto sensu ex curia experts is not reached. The International Court of Justice had recourse to them a few times. The ICLS, Annex 7 tribunals in some cases, and in particular to the South China Sea, which presented peculiar features under the perspective, of course, of procedure. The role of ex curia expert cannot be compared, and I'm passing to my second point, cannot be compared with the role of ex parte experts. We can look for impartiality and independence of ex parte experts, but they are experts coming from the parties. So even if they are expressing knowledge and skills and expertise in specific scientific fields or technological fields, they are always acting with objectivity, but which doesn't correspond to impartiality, and necessarily to impartiality and independence. On the one side, it is easier to utilize ex parte experts, in the sense that international adjudicator leaves to the parties to find them out, to organize their expertise, maintaining a position of an external position from all the process, and intervening only when their expertise has to be presented and assessed. And indeed, the practice shows us a lot of inventiveness concerning ex parte experts. We can find expert witnesses, expert advisors, and expert counsel. This underlines that there is a very thin boundary between witnesses and experts, and maybe a person can play both roles, expressing its scientific opinion at a certain moment, and then testifying, what he could have seen or assisted. The practice of expert counsel have been frequently utilized before the International Court of Justice until the pulp mills case. After that case, a lot of criticisms have been developed on these category. Differently, ICLS have always utilized experts or expert witnesses and have submitted them to cross-examination. And has also elaborated on the distinction between a member of a delegation and experts in the Straits of Johor provisional measures in 2003. If there are, without any doubt, advantages in having recourse to ex parte experts, we must be aware that there are some advantages, disadvantages as well, and in particular the problem of their independence and how to weighing their evidence, the evidence they propose, they present to the international tribunals and courts. I must say that the problem of impartiality and independence is difficult because there is no common understanding on what independence and impartiality mean with reference to experts. There is a study which collects responses obtained by various actors in international proceedings, and the answers given to the interviewers are really different one from the other, passing from the judges through the registrars and arriving to the council. ICLS has a very interesting practice concerning how to assess independence of ex parte experts, since the problem has resulted in a question of admissibility of the expertise. The ICLS, in one case, arrived to consider the evidence non-admissible as it was in the MV Saiga case. It is assisted by a rule, Article 15, paragraph 3 of the Rules of Procedure, which establishes expressly for the independence of the expert as a condition for her admissibility. The International Court of Justice is not assisted at all, since rules are silent on that point. So its practice is less impressive than that of ICLS. Indeed, the problem exists and existed before the International Court of Justice, which tried to have recourse to cross-examination, which is a very good method to ascertain, to assess the independence and impartiality, or Annex 7 tribunals admitted in the past objections to the qualifications of experts. It was the case in the South China Sea case. And finally, another problem, the problem of weighing the expertise from parties when there is a clash of expert opinions, when the international tribunals and courts face completely different and opposing scientific or technical proposal reconstructions by the experts. Rules, relevant rules and statutes, of course, are silent on that situation. We find some only within the WTO system, which is rather different. Here, while the tribunal has asked for cooperation and negotiation between the concerned parties, the International Court of Justice has, on the contrary, tried to return to the legal technique, so to not to face really the problem of clash of expertise, but to solve the problem through legal reasoning, so avoiding in a certain way the problem itself. I think that like domestic judges, international judges and tribunals and courts and tribunals must be well aware of the role which is, utilizing a Latin word, that of peritus peritorum. The judge is the expert among the experts, is the expert of the experts. So he has the capacity to deal with different opinions. And so a couple of words for concluding. In a, I will say, default system, the recourse of ex parte experts is certainly the best solution. But in cases of disputes, such as those, for example, which could involve climate changes, the application of the precautionary principle, or a very detailed scientific knowledge on still debated scientific aspects, the participation to international proceedings of ex curia expert can be very helpful. For example, if the position of ex parte experts diverge, an expert appointed by the judge can give the necessary independence and impartiality. So just to mention one very important Italian, like, to do reference to him, Leonardo da Vinci's time has passed. No one can have universal culture anymore, and this is true also for international judges. Thank you very much.
Well, thank you very much, Ida. Thank you, Judge Caracciolo. You've touched on some very delicate issues that do arise in practice, and I have a feeling that they're not well understood, including sometimes by the parties themselves to the case. So thank you very much.